Welcome once again to Lehto's Law. Here's Steve Lehto.
I got an email yesterday from a gentleman that said, Steve, check this out. He included screen grabs to prove to me that everything he's showing me is what he says it is. And he said that he and his wife decided to get a 3D printer. 3D printer. 3D printers are all the rage now. You get a 3D printer and you can print all kinds of stuff. You can actually print things as opposed to just pieces of paper, right? And he goes, check out the terms and conditions that came with the 3D printer. And he said, we decided that it wasn't worth the risk, so we shipped it back. We decided we did not want to keep the 3D printer with these terms and conditions. So he says, in particular, look at Section 7 with Rule 7.1. Okay? Here it is, verbatim. The laws of the People's Republic of China shall apply to the signing and interpretation of the terms and conditions of this agreement and the settlement of disputes. The laws of the People's Republic of China. Now, we've had disclaimers before that said that if you buy this product or use this service and you want to take legal action against us, you must do so where we are located in Tucson, Arizona. And if you're nearby, that's not a big deal. If you're in Alaska or Maine, that might be a big deal. But choice of venue is something we see all the time, but usually it's just an inconvenient state. The laws of the People's Republic of China. First of all, this is a choice of law. Do you know the laws of the People's Republic of China? Because I don't have them in my blue books behind me. But it does say, just to be clear here, the place of signing this agreement is Hangzhou, Zhejiang province. Now, I could be mispronouncing it. I'm sorry. But it says, if a dispute arises between the user and the company, the parties shall first resolve it through friendly consultation. And if the consultation fails, they agree to submit the dispute to the People's Court with jurisdiction in the place of the signing of the agreement. And remember, the agreement was signed in Hangzhou, Zhejiang. So the dispute will be settled in the People's Court. Now, I don't think the People's Court in China is the same as the People's Court here in America. In fact, I think Judge Wapner isn't doing the show anymore. But, so remember, the agreement was signed in China under the rules of China, okay? The failure of the company to exercise or enforce any right or provision of this usage agreement shall not constitute a waiver of the aforementioned right or right. It actually says that, the aforementioned right or right. And then it says, if any provision of this use agreement is invalid because it conflicts with the laws of the People's Republic of China, you still agree that you shall endeavor to give effect to the intent of the parties reflected in such provision in accordance with the law, and that the other provisions of this agreement shall remain in full force and effect. And what they're trying to get to there was the old thing that says, if any term of this agreement is considered invalid under law, the rest of the agreement still survives. But that's not what they said, but that's what they're trying to say, I suspect. However, I did notice that above 7.1 is a funny one. 6.3, the minor user, M-I-N-O-R, an underage user. The minor user understands that if the user violates laws and regulations and the contents of this agreement, the user and the user's guardian shall bear all consequences resulting from such violation in accordance with the law. Remember, again, the law of China. However, it doesn't say an adult is bound even if they give this to their minor child. They're saying that the minor child shall be able to assume liability for their guardian. And that's not how that works either. Can you imagine? But of course, most people would say, but Steve, come on. A 5-year-old kid can't really order this thing and get it and all that without his parents being involved on some level. But it's just interesting because you'd think that a company with the wherewithal to build and sell 3D printers would actually, hire somebody with some American law background and say, can you just read this agreement or draft an agreement, actually, that will make sense in America that will protect us over here in China. They very well could have just said, if a minor is using this thing, blah, 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 blah. But again, just so you're clear here, if you want to use this printer and keep it, the laws of the People's Republic of China apply to the signing and interpretation of the terms and conditions of the agreement. but also the place of signing the agreement is, in fact, in China. And then if you can't resolve your dispute through friendly consultation, you will then submit the dispute to the People's Court with jurisdiction in the place of the signing, which, of course, is China. And then they don't waive any of their rights. And if any of it's invalid, the rest of it survives. And so this is, I believe, the most inconvenient set of terms I've seen put into an agreement. I've seen them before where they pick an inconvenient forum. I've also seen them where they pick an arbitration process that is known to be unfair. And I've always thought, well, that's the kind of thing where courts will look at that and go, but is this fair, right? And so here's the question. If you were to get one of these 3D printers and then have the need to file a lawsuit over that 3D printer, if you filed that lawsuit here in America, or I don't know, France, England, Canada, some other place, I'm not sure how that works there, but obviously you file the lawsuit here, you'd have to serve them in China. You might be able to find a resident agent for them here if they have one. Some corporations do, but some don't. There's methods you got to jump through, hoops, to get someone served in another country. But presumably, if you served them and said, hey, we're suing you, we're going to sue you in bug tussle. That's as soon as a court in bug tussle. And once they hear that there's a suit being filed against them, they'd probably file a higher American counsel, and the American counsel is going to come into court and wave this thing around and say, hey, the terms of use of this thing say that it's governed by the laws of China, and it's got to be solved there because these rules say that, and they knew this when they got the thing. And so this gets us down to it's a little game of cat and mouse. It's actually more like spy versus spy. But it's a little game between consumers and merchants on these things, because a merchant can impose restrictions on a buyer of goods. And so I'll give you a good example. I'll say I sell widgets that come with a warranty. And if the widget fails in any way covered by the warranty, we will repair it free of charge, at our own expense. But you must bring the widget to one of our repair facilities, or send it to us at your cost, and we'll ship it back to you at our cost. And those kinds of things, people understand that to be that's acceptable. That's reasonable, makes sense, and everyone's familiar with those kinds of warranty exceptions and rules and exclusions and whatnot. But when you start putting in the stuff that says, oh, by the way, if you want to sue us, you got to do it way over here. And there is a ton of case law on that because they've litigated this so much. Because I know that some lenders, for instance, would pick some place really strange and say, oh, all the cases have got to be filed here. And now, if you live far, far away, it becomes inconvenient for you. You can hire local counsel and make it a little easier. But it's still one of those things that's like, but is that fair? And so the question always becomes, how reasonable is this? And how much can you push off onto the consumer and say, but that's still reasonable? And so I don't know what would happen if the attorneys came in from the 3D printing company. Our terms and conditions say specifically that the contract was signed in China and the rules and laws of China will apply in a court in China where this action's got to be filed. Dismiss this case and refile it in China. Which, of course, I suspect one plane ticket to and from China is probably more than the 3D printer cost. And so I am a big believer in the fact that the courts and the laws should say that to enforce something like this, it's got to be reasonable, and it's got to be disclosed to the consumer in a way that they can make an educated decision about it. Because you and I both know what happens is somebody orders this 3D printer, it shows up, they open up the box, they plug it in, they pull out the instruction booklet, and out falls this terms and conditions sheet, which most people never read. But also, that was not visible inside the box, so it was not visible before the box was opened. And I've seen so many things where you go to a store like Best Buy, you buy a product that's plastic wrapped, you bring it home, you open up the plastic wrap, open up the box, pull out the terms and conditions, and there's an exclusion in there that you would not have wanted to buy the product with if you'd known about it. And so the Federal Trade Commission, under the auspices of the Magnuson-Moss Warranty Act, has created some rules and said that if you want to put a term and condition into a warranty, if the warranty is described such that the consumer can see it before the purchase, then the disclaimers need to be there also. But of course, many companies just skip that step and say, who cares? Because what's going to happen is 9 out of 10 people aren't going to read any of it anyway. And by the time we get to court, we're going to say, hey, there's a term and condition there. And did you read it? And I say, of course I didn't read it. You know, it fell out of the box with the styrofoam. So interesting concept. But this is fascinating to me because this is the most extreme that I've seen to date on this. The only thing I think that would make this even more extreme is you picked some uninhabitable Pacific island someplace. I'm saying where there's no humans, filled with wild animals that have evolved strangely due to the lack of contact with other islands, and say that all disputes will be resolved on that island by arbitrators that will fly in. Oh, we'll fly them in at our cost, but you got to show up at the arbitration. That's the next step. And of course, some people in the audience will remember that Hitchhiker's Guide to the Galaxy begins with Arthur Dent attempting to save his house from being demolished to make way for a bypass. And they tell him that the plans have been on display for the length of time required by law down in a filing cabinet in the basement of a building that you can't get into. And it's, I believe, guarded by wild animals. But here we go. If you got this 3D printer, you may have to resolve your disputes in China under the laws of China, unless you can do it through friendly negotiations. So thank you very much for the email, questions, or comments. Put them below this. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. There's your side, there's my side, and then there's the truth.